The Honorable, the Supreme Court.
All right. Good morning. Morning, everybody. Thank you very much. Please be seated. Thank you. Please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled In Re Appeal of S.S., case number 24 AP 111. Representing the appellant, S.S., is Mary Ellen Griffin. Representing the appellee, Department for Children and Families, is Rebecca Ronga.
Okay, thanks. Good morning again, everyone. Students from the law school here, yeah, welcome. Nice to have you here. And so we'll start this case. If you would, counsel, come up to the podium. We have a new podium, perhaps, since you were last here. I don't know.
Yes, Your Honor.
There's some button on the other side. I don't know where it is. Somebody could show you, I'm sure, one of the clerks, to raise it or lower it. So if you need it in a different spot, it's automatic.
Thank you, Your Honor.
Okay, so go ahead, please.
May it please the court. Mary Ellen Griffin, Vermont Legal Aid, for the appellant. This case is about a policy and practice in emergency housing appeals to enter final orders only when the outcome favors the government. Under this system, a case in which a claimant wins will never be fully litigated. This is not fair to claimants, to the department, to the public, and it is not consistent with the statute. I ask this court to reverse the board's dismissal of SS case and remand it with instructions to approve and adopt the findings of the hearing officer, the original findings of the hearing officer, which were based on the evidence received at hearing, and to enter an order based on those findings.
So let's,
Go ahead.
oh, I'm sorry.
No, go ahead, Chief.
If I could jump in, let's talk about dismissal, not mootness specifically, just the concept of dismissal. Are there any circumstances from your point of view where it would be appropriate for the board to dismiss a case?
Yes, before a hearing is held. Justiciability in the statute is governed by Section A of the statute,
Right.
which directly addresses justiciability. To get to a hearing, you have to be an aggrieved party. There are multiple decisions by the board and by this court reaffirming that principle. If you're not an aggrieved party before you get a hearing, you don't get the hearing. But once you get the hearing, the process is controlled by Section C of the statute. And Section C has no less than 4 shalls on it. There's a mandatory process. The hearing officer enters findings of fact, and the board issues an order based on those findings.
Yeah, I know this is your position. I read that in your brief, but there's no express language in any of those sections that I found that talks about dismissal itself, or mootness for that matter. So what you're doing is arguing by implication from the language in those sections. Isn't that true?
No, I'm not arguing by implication. I'm not sure I understand the question. Certainly there's ample case law.
Well, my point is it's not express. That's my question. Is there express language in any of those sections that talks about dismissal or mootness at all?
I am not sure. I suspect that it's in the rules, and I think the statute says that the hearing will be conducted according to the rules. And the rules, I believe, do allow for dismissal before the hearing. So that motions to dismiss can be heard as a preliminary motion before the case in chief is submitted. I believe that's in the rules. So I think the statute says that the hearing is conducted in accordance with the rules, but the rules only allow dismissal before the case in chief is submitted.
And what's the relief? What relief are we empowered to give you now at this stage with that?
I'd like to answer that, but I just want to give you the cite to the rule. It is in the rules, 1000.3L, motions to dismiss may be submitted for the hearings officer consideration prior to the time the case in chief is submitted.
Thanks. Okay.
I'm sorry, Justice Eaton, could you ask me your question again?
So what is the relief we can give you now, given what's occurred in the case?
So there's 2 types of relief that I'm asking for. Relief. One is a remand with instructions to the board to approve and adopt the original set of findings of the hearing officer and to enter an order based on those findings. The other relief I would like from this court is for the court to express its disapproval of this policy and practice of never allowing a case in which a claimant wins to reach a final order. To express that it's part of the point of the Human Services Board to issue a set of decisions to help guide policymakers, the public, claimants, Vermont Legal Aid, as to when are the situations where the department has been right and where are the situations when the department has been wrong. Both sets of cases, both sets of orders are very important to the Human Services Board serving its function.
And how does that function with their goal of providing appropriate housing for the individuals who are using the service? So isn't that really what's going on here? You're looking for this person, she was deprived of appropriate housing with appropriate hearing on the reason why she was removed from the Lamoille facility.
Yes.
And then she's back in so doesn't that fit within the goal of what you're trying to achieve?
I'm not sure I understand the question, Justice. There's no evidence in the record about when she was back in. I don't actually know when she was back in or if she was back in.
Well, the question involving mootness means that there was no longer a case in controversy. I mean, that was what was determined.
There's no evidence in the record that there was no longer a case in controversy.
Okay, so where's the mootness come into?
The claim of mootness wasn't raised until a month after the evidence closed. And there is no evidence in the record of mootness. There's no award letter. There's no statement. There's a claim in a brief a month after the findings were issued. It's claiming mootness, but there was never any evidence taken on this fact. In fact, the appeal brief that was submitted by the state in this case is confusing on this point. I still don't know when and if S.S. was ever housed.
So I'm a little confused, Ms. Griffin. Perhaps you can help me navigate what you just referred to in the record. I thought the hearing officer on March 6, 2024 issued a memorandum acknowledging the appellant's request to attorney report findings and found the department had confirmed they lifted the POI and she was granted all relief she requested.
Yes, the hearing officer did make that finding, Your Honor.
Okay, so I guess maybe I'm a little confused now in terms of if that's the relief that your client has requested, then there's no live controversy. So doesn't the mootness come in at that point?
So two answers to that question. First is that there was no evidence in the record for the hearing officer's finding of mootness. There was absolutely no documentary evidence. There was no testamentary evidence. The hearing was held in January. There was no dispute that there was a very live case in controversy. 3 witnesses were taken testimony under oath, documents, a 4-page single-space written decision was issued. A month later, there was a claim in a brief of mootness. That's it. I didn't actually know whether my client had been housed or not, which was part of the reason why I wanted the record to be clear. So there's the evidentiary problem. And then in terms of the relief my client was seeking a final decision from the board. She had an appeal. She had a right to the process that was set out in the statute. That's what due process requires. You get the process that the law sets out. And the process that the law set out meant that once she got to a hearing, she got a final decision.
Counsel, is it part of this process based upon a policy by DCF that if the hearing officer rules in favor of the petitioner, DCF will automatically go with that decision? Isn't that right? And isn't that extremely beneficial to individuals like your client who are in that position? And so do we want to somehow negate that policy?
Yes, that policy, yes, you are right about the policy. Yes, you are right that that policy benefits people who are experiencing homelessness. And yes, I definitely do not want this court to negate that policy. But that's not an issue here. What's at issue here is the order become finalized.
But if DCF had argued against this, they could have appealed this, right, to the Human Services Board?
Yes, but by their own rules, they would have had to put it into effect as soon as the hearing officer had issued the findings. Their rules require them to put it into effect when the hearing officer issues the findings. In no way negates or cancels out the authority or the duty of the Human Services Board to issue a final order based on the findings, and only those findings that were based on evidence actually received at the hearing. To go back to talking about the statute, this court recently reiterated in KM that the Human Services Board's authority is derived from statute. It has all the powers given to it by statute and only the powers given to it by statute. And that statute is clear. The hearing officer's primary duty is to hold a hearing and to report written findings to the board. And the board's duty is to enter an order based on those findings. The hearing officer does not have authority sua sponte to go looking outside the record for evidence of mootness. And there is
Doesn't the mootness doctrine trump a lot of rules and statutes that might call for a certain process, but mootness can trump those?
I don't know, Your Honor, but mootness is not exactly the right question here. SS went to a hearing, she won. As a matter of law, she has a right to a final decision based on the evidence of that hearing. Part of what happened here is that only the Human Services Board has the authority to actually issue a decision. There was no intermediate decision by the hearing officer, which has been appealed to the Human Services Board. It's one seamless process. The hearing officer enters her findings of fact based upon the evidence received at the hearing. And then according to the rules, the hearing officer is required to simultaneously send those to the board to be approved and adopted and then enter an order based on that. There should be no lag time. Here there was a lag time of 51 days between when the original set of findings were issued and when the Human Services Board actually issued an order. And that is not what is contemplated by the statute or by this court's prior decision. I particularly draw the court's attention to the decision in Pratt versus Department of Social Welfare, which I'm looking for the right quote that I wanted to read you, but it says something like, it's a misconception that the department's decision is appealed first to the hearing officer and then to the board. That is just not how it works. It's one seamless process. Hearing, written findings, order. There is no break. There is no chance to consider mootness.
Ms. Griffin, can you please give me the citation to Pratt case?
I can, yes. 145 VT 138.
Thank you.
I would ask to reserve my remaining time for rebuttal.
Thank you. Thanks very much. We'll hear from counsel for the appellee. Please come on up. Just identify yourself for the record if you want.
Good morning, Your Honors. Please the court. I'm Rebecca Ronga. I represent the Assistant Attorney General, and I represent the Department for Children and Families Economic Services Division.
Ms. Rhonda, I'm sorry for interrupting you in your introduction. Thank you. Thank you.
Thank you. I'd like to ask that you affirm the Human Services Board's decision in this case, dismissing this matter as moot. And I do believe that you heard the appellant's arguments, and it seems that their major issue in this case does relate to mootness and also their dissatisfaction with the HSB's practice of issuing preliminary orders as somewhat of a weather report when the decision is going to benefit or favor the petitioner. And as to mootness, I believe that this case is moot and there is no exception in this case. I think that the HSB can consider whether there's an exception to mootness. And in this case, it was not determined to be meeting an exception. And that's because
I hate to interrupt you so early, but so there seems to be a conflict in the facts regarding whether or not she was rehoused or not rehoused within that 30-day period to make the appeal moot or not moot. Is there a question of fact regarding that?
I found that testimony to be odd, to be honest, that she doesn't know if her client's house She was housed immediately after the recommendation. The motioning mentioned, we motioned mootness, and it was confirmed in motion that the petitioner had been housed. The hearing officer did mention it in their memo, and at no time ever in the pleadings did you ever hear or see the appellant dispute that. So I don't know why there's a question.
So, and that was, is there a question regarding whether it was in the 30-day window or not within the 30-day window?
No, the appellant received relief immediately following the recommendation. So she was, the appellants were motioning for that not to happen. They wanted to open the case and object to the board, which they did and were allowed to. So basically, when the preliminary recommendation came out, it was a weather report, a red flag saying, you're not going to win this case, department. Department went ahead and reversed their decision, and they had the opportunity to object, or else the case is closed. Also, the other party has an opportunity to object, which they did. They objected, we started motioning, which caused a delay. And so if there had been no ask to object, object in front of the board, the case would have been closed. Also, the motion back and forth delayed the case going before the court because the recommendation, a formal recommendation followed, right? She objected, she asked, I want this to go in front of the board. So the motion sort of delayed that to get in front of the board.
But may I ask a question about a specific procedural step here?
Sure.
On February the 8th, the hearing officer said that they would not report the findings to the board and asked for briefing on mootness in 3 weeks, followed by a hearing by the full board. That's out of the appellate record here. Where's the authority for the hearing officer to say, I'm not going to report the findings to the board?
I think that the hearing officers have a great deal of authority in how they, do the procedure and get that, get it before the board. There's nothing in the rules or law that precludes them from sending out a preliminary recommendation to do this, weather report thing. They did send a formal recommendation to the board, and that recommendation was that the matter was moot. And that's why mootness does matter in this case. The case was moot because there was no relief that the board could grant petitioner. The appellant in this case was made whole immediately after recommendation of the preliminary recommendation came out. There was nothing left to ask the board to do. And even, and I know that this court understands that because even earlier this month, there was a case in Ray Appeal of KM, I believe, which the board, the court has referenced Resraitzovich, in which the court held that the board only has the authority to act in a case that affects the petitioner or the claimant, that impacts the claimant, right? And so unless there's a live controversy, unless there's, something that the board can grant that would affect the petitioner's situation or the claimant's situation, they can't act. They couldn't, sorry.
Ms. Montgomery, I just want to clarify. So under, I'm going to mispronounce it, Yakovitz. Is that the pronunciation that?
I'm sorry.
That's it. Unless there is a specific action that affects the
Taken by the agency.
right, it cannot make a broad policy determination across the board. It has to respect an individual's rights.
Right, and that goes to the authority of the board as well.
And that's under KM, Appeal of KM, correct? Is that what you're saying?
Yes, they can. Yeah, so, that goes to, I'm sorry, I lost my train of thought. There was no relief that the board could grant, essentially. And so in this case, the matter was moot. The board couldn't, they couldn't affirm, reverse, or modify, which are the only things that the board can do. They couldn't affirm a reversal because the reversal had already happened. There was no action they can ask the agency to take to grant relief, right?
What is your rejoinder to the claim that under 3091, they're entitled to an order, even if
They
the,
received an order,
and the order was that it was moot?
yes.
Okay.
So I do want to talk about the preliminary order and that process, because and as the appellant spoke about, the department and my client does have a policy. They put this policy in effect in 1986, very long-standing policy. Okay, and this policy gets the relief to the petitioners expeditiously. That's the reason for that policy, right? Because they're unhoused, they're hungry, they're cold, and if they get a red flag from the HSB saying, or the hearing officer saying, you're going to lose this case, they want to just fix it immediately. They want to get that relief to petitioners. But they don't require the preliminary recommendation. That is a mechanism that the HSB does in concert with the effort and willingness of the department to get the relief expeditiously, right? So I think that disrupting that, that working it would be detrimental to petitioners in the future that are similar situated to appellant. And so I ask you not to do that. But so I think that, you know, in the big picture, the department doesn't, you know, have anything to do with that preliminary recommendation, but it definitely, it works with their policy to get expeditious relief. And so,
So is it your view that the case is over as soon as the department reverses decision that she was inappropriately removed from the housing?
it can be. So that preliminary recommendation comes with a caveat at the end, like if any party objects to closing this order, you may object and we'll bring it to the board. The formal recommendation will be provided to the board. And it was provided to the board that the matter was just, you know, should be dismissed as moot because there wasn't anything left for the board to do. But that recommendation did go to the board and they did rule on that. And they affirmed that they should be dismissed as moot. They agreed. So
That she was eligible for housing, that it was appropriate for her to be eligible for housing.
that wasn't the question because it had already been reversed and the department agrees she's eligible. She's been given housing. We reported to the hearing officer that she'd been housed. And so there was nothing that the board could rule on. And so that brings me back to the point of the authority of the board. The board's authority can't grow. They can't expand on it. They can't give advisory opinions. That's not one of the things that they have authority to do. That's not in their scope. If they were to rule on, if say the appellants got exactly what they wanted, that the hearing officer had sent a recommendation over to the board that said reverse the department, but the department had already reversed. That's an advisory opinion. They don't have authority to do. They don't have authority to give that. They have to dismiss it. And the only way that they could come to anything other than dismissal was if the case met an exception to mootness, right? And it doesn't, and they determined that it doesn't.
I have a question about that. One of the exceptions to mootness is whether the same party may be subject to the same action again. And if this is an ongoing policy that DCF abides by the hearing officer's decision, and therefore an order doesn't get to the board, why is that not an exception to the mootness requirement? Because it's likely that this will keep happening, right? It has been.
But that's not what is argued for the exception in mootness. They're arguing that the occurrence of her continuing to be unhoused might repeat itself in the same manner. And it would have to be more than just a theoretical possibility, right? It'd have to be a reasonable expectation. She would be in the future, put out by a shelter for, for rule violation, of the shelter. And it's not reasonable to expect this set of circumstances, if you read, is super unique. And really, it's not reasonable to expect that it would happen again, right? In conjunction with the fact that we don't know what the rules would be in the future. So rules are always changing. I'm sorry.
Are we just looking at this one individual when we
Well,
apply that exception? In other
Yes.
words, can we decide that it's an exception to mootness because many people are subject to this process?
It's person specific. Yeah, they would look at the specific of the case, and in this case, like I said, very unique. The rules change frequently in this program and have changed frequently. In fact, since the HSB review, the rules have changed. And if appellant were to find themselves in the exact same situation today, we wouldn't be here. There wouldn't be an assessment of a period of ineligibility. The rules have changed. It doesn't exist anymore. So it would basically be impossible for that situation to repeat itself. Thank you.
Okay, thank you. Yep, thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes and 32 seconds remaining.
Counsel?
Thank you, Your Honor. There are 3 issues I want to address on my brief rebuttal time. First is, when did SS receive housing? The second is capable of repetition and evading review, exception to mootness. And third, why does this case matter? So first, as to when did SS receive housing? Today is the first time that I've heard that she received housing immediately after the hearing. Immediately after the hearing, I was unable to reach my client. I spoke with opposing counsel. Opposing counsel said they did not oppose the decision of the hearing officer. I filed an unopposed motion to finalize the decision. It was important that the record be clear for when my client was homeless and unsheltered in a Vermont winter, for when she showed up at a district office, for the record to be crystal clear that she was entitled to housing. She had a right to that clarity in the record, and that's what we asked for. And at the time, it was unopposed. It was not until the hearing officer later, sua sponte, ordered weeks of briefing on mootness. That was what reopened the record, or that's why the whole delay happened. It was not because of an objection on my part. At the time that I requested the hearing order be finalized, there was no objection to the findings. So there is nothing in the record about when she received housing. I don't actually know. My client's here, I can ask her later, but I don't know. I couldn't find her until after, when the time came to appeal. I was able to find her through a mutual person, and she agreed to do the appeal. And she's here today in the courtroom. Second, in terms of capable of repetition and evading review, SS is still homeless. She is unsheltered. She is living in a tent in the woods. She's still trying to get into emergency housing. So it's certainly capable of repetition and evading review.
But is that due to anything involving this case? Her situation, which is awful, but does that have to do as a result of this case? Because she was placed back in housing.
I mean, I have no reason to doubt. Yes, she told me that she was back in housing. I don't know exactly when that happened. But when I talked to her yesterday, she said, yes, I was in, and then I was removed from another period of ineligibility, and now I'm still out. I'm trying to get back in. I haven't confirmed any of that with the department. I don't actually know, but that's what SS told me yesterday. So does it have anything to do with this case directly? No, but indirectly it does, because the system of emergency housing is so in flux and is so confusing. And so having a body of decisions from the Human Services Board about how the program is working, about how it should be working, about things the department has done right, and things the department has done wrong, is really, really important to inform the discussions at the department, at the Legislative Committee on Rules, at the legislature, at this court, about how the system is supposed to be working for people who are homeless and in desperate need of emergency housing. I did want to say something else about capable of repetition and evading review. And that the periods of ineligibility are appealed very frequently, which I think Justice Carroll sort of suggested, because they're so fact specific, and because the deprivation of emergency housing is such an extreme penalty to impose on someone, that they are very frequently appealed. And under the present system, the record will only reflect when the government is right, not when the government is wrong. And you could never litigate a favorable case. I can see that I'm out of time. Thank you, Your Honor.